boy, Kyle Rittenhouse.
Let me go first.
On the stand
Let me
today.
go first.
He was just sitting here. Scott, I'm still talking. Damn it, wait. I ain't even done an intro yet to the story, and your ass ready to talk. So, man, he was sitting here crying. Stop talking, Scott. Y'all, mute his mic till I get done. Kyle Rittenhouse go on the stand today, y'all. He's sitting here whining and crying. You got the judge. He's sitting here admonishing the prosecutors. He's acting more like a defense attorney than an impartial judge. And so here's a video, again, of Kyle Rittenhouse on the stand. He is the young white man who killed two folks in Kenosha, Wisconsin, AR-15. Of course, he traveled to a neighboring state to so-called secure the city. Watch this.
To go in a northerly direction?
I wasn't.
Describe what happens.
Once I take that step back, I look over my shoulder and Mr. Rosenbaum was now running from my right side. And I was cornered from in front of me with Mr. Zeminski, and there were three people right there.
Take a deep breath, Kyle.
That's what That's where I run.
We're going to just take time for our break anyway. You can just relax for a minute, sir. We're going to take a break about 10 minutes, and please don't talk about the case during the break. Read, watch, or listen to any economy trial.
But he kept chasing me. It didn't stop him.
Mr. Rittenhouse, you're telling us that you felt like you were about to die, right?
Yes.
But when you point the gun at someone else, that's going to make them feel like they're about to die, right? That's what you wanted him to feel.
No.
You wanted him to get the message from you that if you come any closer, I'm going to kill you. That's why you pointed the gun at him, right?
I pointed the gun at him to deter him from... I pointed the gun at him so he would stop chasing me. That's why I pointed the gun at him.
Because if you point the gun at him, you were hoping he would stop chasing you because he would get the message from you that if he keeps coming, you're going to kill him, right?
I didn't want to have to kill Mr. Rosenbaum.
That's not the question I asked.
It seems argumentative, Mr.
Did that even factor into your mind at that point? Did you even care whether you were going to kill him or not?
I didn't want to have to kill anybody. I was being attacked. That's why I shot him. Shot at him.
You shot at him with the intent of hitting him and killing him, correct?
I didn't want to kill anybody.
Then why are you shooting at someone with an AR-15 at close range if you don't want to kill him?
Because he's attacking me.
All right, folks, and so now, if y'all want to see somebody who really, really rehearsed his tears, watch this.
My
folks,
right side, and I was cornered from in front of me with Mr. Zeminski, and there were three people right there.
Take a deep breath, Kyle.
That's what That's where I run.
We're going to just take time for our break anyway. You can just relax for a minute, sir. We're going to take a break, about 10 minutes, and please don't talk about the case during the break. Read, watch, or listen to any account of the trial.
But he kept chasing me. It didn't stop him.
Mr. Rittenhouse, you're telling us that you felt.
It was just, oh, I'm just being hurt. Now, the judge in this case, he just went after the prosecutors. Watch this.
Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? You are already, I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, well, I'll leave it at that. So I don't know what you're up to.
There have been numerous occasions during this trial where they've opened the door. The one time when they're going into Mr. Rosenbaum's prior, the reason he doesn't like guns, and I said something, I whispered in Mr. Krause's ear, it's because of the prior convictions. Please stop, and he did. He knows if you're going to go into something that's been excluded in a pretrial order, you better ask the court, you better get permission. This is ridiculous.
It wasn't excluded, Your Honor.
You know why it was excluded in the first place? Because it was propensity evidence. That is exactly what 90404 is designed to prevent. You're talking about his attitudes. His attitude is he wants to shoot people. Now, I've admitted that kind of evidence in other trials when it's been appropriate. I didn't admit it in this case because, to me, what I've heard in this trial, and by the way, Mr. Richards absolutely correctly points out that just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the defense
Don't
testimony.
get brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that. That's number one. Number two, this is propensity evidence. I said at the time that I made my ruling, and I'll repeat again now for you, I see no similarity between talking about wishing you had your AR gun, which you don't have, so that you could fire rounds at these thought to be shoplifters, and the incidents in these cases, which are not, there's nothing in your case that suggests the defendant was lying in wait to shoot at somebody or reflecting upon the shooting for a vast amount of time. Every one of the incidents involves matters that involve seconds in time. So I commented at the time, I don't see the similarity, and I don't see the similarity now. You have an incident where he's making comments about some alleged shoplifters versus crimes that involve instantaneous actions, whether premeditated murder or whether self-defense. That's for the jury to decide. But I don't see the similarity. I said it couldn't come in, and it isn't coming in, no matter what you think. Number two, I have to be concerned that with what Mr. Richards has said about the progress of the trial, and when you were I said you were over the line, close to or over the line on commenting on the defendant's pretrial silence, which is a well-known rule. I'm astonished that would have been an issue. So I don't want to have another issue as long as this case continues. Is that clear?
It is.
Thank you. Ask the jury to come back in, please.
Okay, let's get right to it. Scott, now you can talk.
Okay, this is going to be a little complicated. Let's unpack it for the judge, okay? So he makes a pretrial ruling, this judge, and he says that the fact that they had this prior videotape or recording of the defendant saying, pardon me? Anyway, we're going to unpack it. And so they have this prior recording of the defendant saying, I'd like to take my AR and shoot some people coming out of a store, a completely separate incident. The judge ruled that that couldn't come in because, as he says, it's propensity evidence. That is, the propensity for the jury to believe that his desire to shoot an AR-15 on a prior occasion plays in some way to his intent for the night in doing the rioting and what have you. And the judge said that's mutually exclusive. The prosecutor tried to bring it in, despite that ruling, saying that his ruling, the judge's ruling, opened the door or did not close the door to that level of inquiry. The reason that's important is because it's highly prejudiced versus the probative value. And if he does that, if he brings that in against the judge's order, or if he questions the defendant about whether he told the police something or not, and he's got a right to remain silent under the Constitution, that's grounds for a mistrial. In fact, the defense attorneys moved for mistrial, and the judge almost granted it. This doesn't have to do, as I see the video, have to do with whether the judge is acting for the defense or in support of the defense. This is kind of fundamental trial work and evidence and rules that defense lawyers and prosecutors cannot violate, because you can get a mistrial on this, and it's a waste of time, money, and resources when you have to start all over again. And so that's the unpacking piece. I think the judge was right here, but he did not grant the mistrial because he wants to get this trial done. But the prosecution has to stay in line. Now, I don't think long-term that's going to have a prejudicial effect on the prosecution. Judges move on, and you get berated by judges all the time if you screw up. But here, I think the judge was right, at least had an argument for why he was highly pissed off, if you will, with the prosecution. And lastly, I don't know what the defendant was doing, because he said he looked like he was having an asthma attack more than crying. I didn't like to laugh at people who were being emotional, but that did seem contrived. So those are my best thoughts, Roland.
Monique, you have this judge who, again, has ticked up a lot of people who, you know, first of all, he made it clear that the prosecutors could not call the two people who were killed victims. Called them rioters and looters. That's fine as well. There are many who believe that this judge has crossed the line numerous times and acting more as if he's in the corner of Kyle Rittenhouse.
Yes, but the people who are saying that are not career criminal defense attorneys.
Exactly.
And I disagree with some of the things that the judge has done, but in that I think that there were closer calls on victim, rioter, looter, language, things like that, even though the thing that I will add to everything Scott said, which I 100% agree with everything that Scott said, what I will add to it is it can be difficult for lay people to separate a judge's nasty personality with a judge's rulings in applying the law. And this judge runs hot. That's his temperament.
Exactly.
He did not run hot. He did not run hot in front of that jury. He got his jury the heck out of there, and then he read for filth the prosecutor for doing something that the prosecutor should have never tried to do, was stupid to do, wouldn't have gotten away with. And in DC, it wouldn't, I don't know if the mistrial would be granted or not, but the likes of Tanya Chutkan, who just did the ruling saying that the Trump files are not going to be secret, she would have stepped a lawyer back over some bullshiggity like that. She'd like, think this over in one of my jail cells. The bailiff will show you what happens when you screw with my jury. Think it through, counselor. You work for the government. You don't take cheap shots. You don't try to sneak things in front of the jury before you talk to me, especially if you know I'm the kind of judge that runs hot anyway. And we've been fighting back and forth about this. Okay, if you think the door was open through the defendant's testimony, you ask the lead up questions, and then you say, Your Honor, may we approach? And then you approach and you say, Your Honor, I believe based on the answers that I've just received from the defendant and based on the prior testimony on direct examination, This now should come into evidence, and I would like to be heard. And then judge is going to say yes, the judge is going to say no. You stick it in your folder for mistrial if you get denied. These prosecutors are getting out-lawyered. Hold this up against the trial that we saw against Chauvin, where you saw prosecutors do one of the best jobs of prosecuting a criminal case I have seen. And I don't, never in my life have I liked the job that a prosecutor does, in that I'm just, in my spirit, a defense attorney. But they did a good job and they got a conviction. These dudes right here are screwing up. And yes, the defendant had his contrived breakdown, and I don't know how long they had to practice for Rittenhouse to do that contrived breakdown. Obviously, they still couldn't get him to shed one single tear, but they worked him hard. And when you have a whole bunch of white folks on a jury, seeing who they're going to think is a boy, who they're calling Kyle, and he's doing that, hyperventilating, scrunching his face up, you know, looking at the judge saying, help me, please. Yeah, it might work. So no, I don't like the way this case is going. I texted everybody and said I believed it would be a SH show from start to finish, and I stand by my estimation.
Robert Patillo, is this judge doing a proper job? Is he coming across as being more sympathetic to the defense? Should he recuse himself?
No, the judge is doing a fine job. The prosecutor is the one messing up. And I put myself in the position of that defense attorney. I've been a defense attorney my whole career. If we have a pretrial motion and the judge rules on what can and can't come in, and now you just try to sneak something in against the pretrial order that we issued, I'm flipping the table over. I'm literally flipping the table. The one time I got put in handcuffs in court was when a prosecutor tried to do something similar to that. And I blacked the F out in the middle of the Fulton County courtroom. They had to put handcuffs on me to stop me from literally going up on the bench. That's what you have. That's called zealous advocacy for your client. You got to be willing to take it to the mat for your client. So if the prosecutor has already agreed and it's already been ruled on before trial, and you're trying to sneak something in, I'm not trying the rest of the case. We're already at mistrial here. I'm already talking to my client when he gets off the stand and saying, look, regardless of what happens, we're ready for appeal, even if you do get convicted here. So this is one of those incompetent prosecutorial jobs I've ever seen, because even if you play that the cross-examination back that the prosecutor was doing, and that's what I keyed in on, that section, the cross-examination. The defendant does not get to talk during that cross-examination except yes or no. So I am testifying for you. I'm basically reading through the facts that happened and shaping them to the way that I want them read out. And you're saying, did you cross state lines? Yes. Did you bring a loaded firearm with you? Yes. Did you have any legal responsibility to be there? No. Did you walk around brandishing an AR-15 in a crowded protest? Yes. Are you a law enforcement officer? No. Do you have any training which allows you to do crowd control or to patrol businesses? No. Did you aim your firearm at an individual? Yes. Did you shoot that individual? Yes. Did that individual die? Yes. Done with my questions. You don't have all this back and forth.
Well,
you sit down. You don't do all this back and forth. You keep it tight and you get on out.
I agree, except for
Monique, go ahead.
I would want each one of those to be leading, though, Robert. You know, you crossed state lines, you didn't have, et cetera. I would switch those up a little bit. But then what they also missed is the dude breaks down on the stand. You have contemporaneous video of him with no tears, skipping my Lou Daisy down the street after shooting people. You're not crying there, are you? I mean, they get in trouble for trying to talk about his emotion and his propensity for wanting to shoot folks, but you have the evidence. Why aren't you playing the video of what he looked like after he shot at the first set of people? Where are the tears? Where's the hyperventilation? Are you calling 911? Are you trying to assist? Are you even running away? Are you saying you're sorry? What in his actions looks like what they contrived on the stand today? No, the prosecution is trash right now.
And Monique, on that point, just real quick, what was his statement immediately after the shooting when he talked to his friend? Did he say, oh my God, these people were trying to kill me. I had to defend my life. I was in a life or death struggle and I had to defend myself. He ain't saying none of that. What did he say? I just killed 2 people. That is what he said. So the prosecution
and that his life might be over. And that his life might be over.
Exactly.
I'm telling you.
That was without the lawyers and without being in the courtroom and without the publicity and my ass being locked up. That's the contemporaneous emotion you all are talking about. And that's the rebuttal to the tears. But you have to be fearless to do that as a lawyer. You know, everybody gets caught up in the emotion and say, oh, but leave that crying witness alone. No, you can really, a matter of factly say, okay, you're crying. Let's put the video up, though. Within seconds and minutes of shooting those individuals, you did this, didn't you? Point to the video. You told them you killed 2 people, right? You didn't say you were sorry or anything else.
Water. I will pour the water for you. I will pour the water for you because you need a drink. I will give you your Kleenex. We will wait for however long it takes. I will give you a hug. And then we're going to talk about this video because you're a murderer.
Right. And you don't run from that crying witness. You run to that crying witness, right? You show the jury that I'm good with his tears, but I got something else for you. This is when he wasn't crying. This is when he wasn't crying. You see?
Yeah. Last point for me. When you were leaving the scene after killing 2 people and shooting a 3rd, you approached officers, correct? Yes. And when the officers told you to leave, did you tell them, there is a group of people trying to murder me and I had to protect my life? You should go investigate. Or did you go home and go to sleep?
Or come with me. Come with me to catch them. Because there's a gang after me.
There's an angry mob trying to kill me. I'm going to head on home with my mom. Well, that makes no sense, and the prosecution is not keying in on that. When you have the defendant on the stand, if this rarely happens that you get the defendant testifying his own defense, this is your opportunity to shine. This is your chance to moonwalk all the way around the courtroom. You're supposed to look like James Brown in there. I mean, just tearing him down piece by piece. Yeah. And the prosecutor, like he just got out of Mickey Mouse Law School. I'm not quite sure.
Well,
go ahead, Scott.
Here's the problem, though. Okay, and you see this. I see this all over the country because prosecutors don't have as much experience cross-examining witnesses the way defense attorneys do, because very seldom are defendants put on the stand. They have to put their defendant on the stand because they need his testimony. They can't get it from anywhere else, and there are a lot of risk associated with that vis-a-vis cross-examination. But the prosecutors aren't really good at cross-examination because they don't do a whole lot of it. And you're seeing this manifestation across, but not one of any level of experience or expertise. The issues we're raising, when you put your cross-examination together, you ought to be thinking and raising those issues months before, because you know this moment is a possibility, and in this case, a probability. And they lost that war. The whole case is about this guy, this defendant, and he took the stand. This is the moment. You have to win that moment. Now, you might still win the case, maybe, but there's a lot of self-defense, powerful self-defense evidence that came in through the defendant. And I got to tell you, many of the other witnesses, we haven't talked about those, Roland, the other witnesses who were the victims, the victim that survived, and some of the other people who observed all this, they either gave conflicting testimony or they gave testimony that really helped both sides. That's the real killer issue, because the jury is going to have to sort through that, and reasonable doubt, if you've got a reason to doubt it, that's reasonable doubt. And the defense and the witnesses for the prosecution have given a lot of reasonable doubt or evidence that's going to make the jury struggle. If the jury struggles, they're going to come up with a defense verdict and a not guilty verdict. So the prosecution has to rally. They've got some time, but you don't know how many defense witnesses there are going to be. There may not be any more after that. And then you've got to put on a closing argument like you've never done before to convince the jury to choose your story and not the defense story in this case. We'll see.
And Scott, just kind of touching on that previous witness. Well, just last point, Roland.
No, Robert, go ahead. Final comment.
touching on that previous witness, the individual who was shot and survived, as the prosecutor, you have to protect your witness. You got to object. You got to break that cycle. You can't just let him get up there and get turned into circles. And you make sure you prep him to say, yes, I had my gun as I was approaching Mr. Rittenhouse because he had an AR-15 and was walking around stalking people out trying to defend the rest of the crowd. They just let that entire opportunity go, and now conservative media is running around saying, see, told you it's justified. So the level of incompetence is hard to even understand, and the magnitude of this failure, if he does get acquitted, lies directly on the state.
Yeah, you gotta prep that witness to fight the defense cross.
Scott, which part of final comment don't you get?
Oh, I didn't hear that final. I thought you were gonna go back around.
Yeah, I said, Robert, final comment on this topic.
God, I miss you, Roland.
You
miss me? I miss you.
Going to a break, folks. Stop talking. Going to a break. Back to our Roland Martin Unfiltered video in just one moment.
Once upon a time, there lived a princess with really long hair who was waiting for a prince to come save her. But really, who has time for that?
Let's go. Feeling myself. I'm feeling
She ordered herself a ladder with Prime one-day delivery, and she was out of there.
I want some hood girls looking back at it and a good girl in my tax bracket.
Now, her hairdressing empire is killing it. And the prince, well, who cares? Prime changed everything.
Time to be smart.
Roland Martin's doing this every day.
Oh, no punches!
Thank you, Roland Martin, for always giving voice to the issues.
Look for Roland Martin in the whirlwind, to quote Marcus Garvey again.
The video looks phenomenal, so I'm really excited to see it on my big screen.
Support this man, Black Media. He makes sure that our stories are told.
See, this difference between Black Star Network and Black-owned media and something like CNN.
I got to defer to the brilliance of Dr. Carr and to the brilliance of the Black Star Network.
I am rolling with Roland all the way. Honored to be on a show that you own. A black man owns the show.
Folks, Black Star Network is here.
I'm real revolutionary right now. Roland was amazing on that.
Stay black. I love y'all.
I can't commend you enough about this platform that you've created for us to be able to share who we are, what we're doing in the world, and the impact that we're having.
Let's be smart. Bring your eyeballs home.
You can't be Black-owned media and be scared. You dig?